I've had a few comments like this, pointing this out. In the original video, I said multiple times that you cannot have a public order offence in private. What I meant by this, and what I should have said, was you cannot have a public order offence in a private dwelling. The law states that if the defendant and alleged victim are inside a dwelling house, then the offence cannot be made out. The definition of a dwelling is contained within Section 8 of the Public Order Act 1986 and is as follows. Dwelling means any structure or part of a structure occupied as a person's home or as other living accommodation, whether the occupation is separate or shared with others, but does not include any part not so occupied. And for this purpose, structure includes a tent, caravan, vehicle, vessel, or other temporary movable structure. So one could make the argument that the girl was in a private domicile and will not be harassed. Bitch. I'm also going to briefly explain sections 3, 4 and 5 because they've been mentioned a few times in the comments as well, and why they do not apply to this specific incident with the autistic girl. Section 3 of the Public Order Act deals with the offence of affray. Affray is often alleged in domestic violence situations, especially as unlike other public order offences, it could be charged for an incident that occurs within the home. Proving an affray isn't straightforward. It must be proved that a person has used or threatened unlawful violence against another, and his or her conduct is such that it would cause a person of reasonable firmness present at the scene to fear for his or her personal safety. Words are not enough. The behaviour of the accused must put another person in fear, but it is not relevant that the victim was put in fear. There has to be violence of such a kind that a notional bystander would fear for his or her personal safety. So where the violence is focused solely and exclusively on the victim, such that it would be incapable of causing a person of reasonable firmness present at the scene to fear for his or her safety, then the offence of the affray would not be proven. An example of affray is a fight between two or more people in a place where members of the general public are present. The accused must have intended to use or threaten violence, or have been aware that his conduct may be violent or may threaten violence. A neurodivergent teenager who speaks without thinking, comparing a police officer to her lesbian grandmother, does not fit this criteria. It would be a massive reach to suggest otherwise, and it would set a very dangerous precedent. There is an overlap in the conduct required to commit any public order offence. However, the police cannot charge affray for incidents within a dwelling just because a lesser public order or assault charge is not available. Section 4 deals with threatening behaviour. It is less serious than affray, and his maximum sentence is 6 months in prison. Threatening, abusive or insulting words or behaviour towards another person in public or a private place, but not in a dwelling, either with intent to cause that person to believe that immediate unlawful violence will be used against him or another by any person, or with intent to provoke immediate use of unlawful violence by that person or another, or whereby the person is likely to believe that such violence will be used, or it is likely that such violence will be provoked. Examples of threatening behaviour include threats made towards innocent bystanders, throwing objects where no injury is caused, scuffles or incidents of violence or threats of violence, such as disturbance in or outside a pub or shop. The key defence is reasonable conduct. It is for a court to decide what is reasonable after considering all of the relevant circumstances. Finally, we get to Section 4A and Section 5 public order offences. Section 4A requires threatening, abusive or insulting words or behaviour or disorderly behaviour in a public or private place, again, not within the home, with intent to cause and thereby causing harassment, alarm or distress. Section 5 required threatening or abusive words or behaviour or disorderly behaviour in a public or private place, again, not within the home, with intention or awareness that behaviour may be disorderly, or with intention or awareness that such behaviour may be threatening or abusive, with the hearing or sight of a person likely to be caused harassment, alarm or distress. The main difference between 4A and 5 is the need to prove intent for a Section 4A offence. That provides significant wriggle room, as without an admission, intent is not easy to prove. So with all the above in mind, this is grounds for unlawful arrest on false charges, which is what I originally meant in the video, but I messed that bit up, so I hold my hand up. I misspoke. When I said in private, I was referring to a dwelling, so that's my bad. My apologies. For those wondering what the website I was reading from was, it's from this rather happy-looking chap, Richard Bayliss, a freelanced criminal defence solicitor. And the reason I chose this rather than the government's own website is because the government's own website and definitions of laws is very, very, very complex and wordy in a lot of cases. I think in some instances, just like with government policies, they are worded like this deliberately just to bore the living tits off of you. However, if this teenage girl was to go on a violent tirade about lesbians and then proceeded to throw some punches at the police officer or attempt to, even if she wasn't a police officer, that would be grounds for prosecution. But in this instance, she didn't. It was just a comment about what she looked like, and the police officer took that personally.